as Annette said, I have no slides, and I'm going to be pretty much the opposite of the previous presentation, in that I'm going to talk more about humans and less about technology. I am a human rights lawyer. I've spent 25 years working on human rights on various different issues, and most recently on human rights and technology. And I'm going to talk about the human rights framework, the equality framework, and how those engage with fintech when fintech impacts on humans, in particular on consumers. So first of all, really just to give a bit of a frame about why human rights and equality are relevant for fintech. And I'm going to look at it primarily from a UK perspective and a UK regulatory perspective, but there will be parallels in other countries and more broadly. So human rights law generally is designed to manage what our governments can do to us and how our governments impact on our lives. But that also includes our governments making sure that we treat each other well, that we don't destroy each other's human rights, and that businesses or third parties can't destroy our human rights. And so at the United Nations level, to reflect this broad idea of human rights protection and the need for effective human rights protection, the guiding principles on business and human rights make it clear that businesses have to respect rights. And that means not only that businesses should avoid infringing on the human rights of people that they engage with, but also that they need to address the adverse human rights impacts that they're involved in. So that means not only making sure that you don't impact on someone's human rights, but also making sure that any of the tools that you're using are human rights compliant. So in the UK, we have since 2000, the Human Rights Act came into force, which meant that all government actions, but also interpretation of legislation and how things work in our country, need to be read through the prism of the Human Rights Act. And the rights in the Human Rights Act reflect the rights that we see in the European Convention on Human Rights. And those include, beyond things like the right to private life, also things like the right to freedom of thought, the right to freedom of association, the right to freedom of assembly, and a whole range of rights, the right to a fair trial, that can affect us in our daily lives. We often don't think about our human rights until we really need them, until we feel that there's been some kind of injustice that affects us. And that is when we realize why human rights matter. And in the UK as well, since 2010, we have the Equality Act in force. And the Equality Act means that businesses, but also regulators and government bodies, have to take action to eliminate discrimination, harassment, victimization, and other kind of conduct prohibited by the Act. And that means advancing equality of opportunity between people who share a relevant protected characteristic and those who do not. It's about levelling up, which is something that we hear a lot of spin about, but what does that actually mean on the ground? So under the UK Equality Act, and you'll see similar things in international law and European law, protected characteristics that you need to bear in mind when thinking about equality and non-discrimination include things like age, disability, gender reassignment, pregnancy and maternity, race, religion or belief, sex, sexual orientation, marriage or civil partnership status. But that's really just the beginning of what equality is about, that list of protected characteristics. But those are key if you're looking at compliance with the UK Equality Act. So how does that work in practice when you're talking about financial services? Well, in the UK, the regulator is the Financial Conduct Authority. And Principle 6 of the Principles of Business from the Financial Conduct Authority is that a firm must pay due regard to the interests of its customers and treat them fairly. So treating your customer fairly and having regard to the interests of your customers has at its heart the idea that you should be treating them fairly according to the Equality Act and that you shouldn't be doing anything that breaches their human rights. So we have the regulator, the Financial Conduct Authority, and the Financial Conduct Authority governs and regulates what financial businesses are doing in the UK. And an interesting bit of work that they have been doing is their ongoing consultation on treating vulnerable customers fairly. And as we're sitting in the middle of a pandemic with wide swathes of the population around the world facing both economic hardship and human rights challenges, this question of how to treat vulnerable customers fairly is going to be increasingly important for financial services providers. So what happens in the UK if you as a consumer feel that a company has not treated you fairly, that they haven't had due regard to your interests in the way that they are dealing with you? Well, what you do in the UK is you complain first to the business, and if you don't like the answer that comes back, then you complain to the Financial Ombudsman Service. And the Financial Ombudsman Service then looks at your complaint, decides on a first review what it thinks, and if you disagree with that, your complaint then goes to an ombudsman. The ombudsman looks at everything that you've provided and that the business has provided and decides whether or not, in all the circumstances of the case, the ombudsman feels the outcome is fair and reasonable. So an ombudsman decides what they think is fair and reasonable in all the circumstances of the case, taking account the business's obligations under regulatory principles, but also under that broader framework. It's unlikely that something that has a negative impact or that violates the human rights or the access and equality of a consumer is going to be a fair and reasonable outcome. So what does all that mean when you come to algorithmic risk assessments and risk assessments of personal customers? So looking at this question, and it goes back to, I don't know who remembers the Little Britain sketch show, when there was an ongoing sketch of people going to ask the bank whether it was for a mortgage or a loan or whatever it was to fulfill their dreams. The clerk would put in all the information into the computer and come back and say, computer says no. And we all know that horrendous feeling of waiting to see what the outcome is going to be if you've asked for access to financial services. And as Nanny discussed earlier, access to financial services, access to credit, access to mortgages, and access to insurance in many places, which in turn give you access to health, are increasingly being viewed as something that's absolutely necessary for fulfilling your economic, social, cultural rights and fundamental human rights like access to health. So what do you need to bear in mind as a financial services provider when you are starting to use computers and see how the computers are going to assess whether or not you want to give credit to somebody and on what basis? As we see decisions on credit and on insurance, in particular risk assessments, personal risk assessments developing, they are increasingly empowered by data enrichment. So one of the first questions you need to ask is, what data is being used in a personal risk assessment, and what is it being used for? What exactly are you assessing, and how are you doing it? One of the most important things you need to bear in mind when you are using data enrichment is that if you are asked by the Financial Ombudsman how your decision was fair and reasonable, are you going to be able to explain what exactly the algorithm considered and why what it considered and the decision and conclusions that it came up with were fair and really had your customers' interests at heart? One of the questions around that is whether or not the data that's being used could be discriminatory. And for that, you really need to understand what data is going into your risk assessment. Some forms of data may be a proxy for protected characteristics. So even if you're not discriminating directly, indirect discrimination is also unlawful. So for example, the Sun newspaper last year ran a story about how by putting in exactly the same information on a car insurance, for a car insurance quote, if your name was Mohammed Smith, you would be paying roughly double what you would be paying if your name was John Smith. And now some of the insurance companies came back saying, well, no, this is just because it was flagging up fraud. Well, even if the algorithm is about flagging up fraud, you need to be very clear and very careful about what it is in the information that the algorithm is picking up as flagging as fraud. And similarly to the earlier discussion around cats and what it is to know whether it's a cat, that won't wash if the outcomes of your risk assessments turn out to be discriminatory. There isn't a protected characteristic of being called Mohammed or being called John, but it's pretty clear that being called Mohammed is a proxy for a protected characteristic or a group of protected characteristics. And so just stepping away and saying we don't discriminate on religion or ethnicity is not going to be enough to satisfy that requirement to treat your customers fairly. Going beyond discrimination and beyond privacy and data protection, I think it's also interesting to explore how far data is being used to try to identify what kind of people we are, what's going on underneath our skin, what's going on behind what could be described as protected characteristics. And in late 2016, Admiral announced that they were going to put an app on Facebook, which was going to allow young drivers to give Admiral access to all their information on their Facebook feeds, so that theoretically they might get a nice reduction in their insurance premiums by demonstrating what a trustworthy and reliable kind of person they are. And interestingly, the way Admiral described the scheme, they said it was going to help them identify personality traits through examining posts and likes on Facebook, although not photos. So this kind of question of compliance with data protection, where people have become sort of obsessed with whether or not they've got your name or whether or not you're looking at the photo, actually the kind of data and the way that data is being used can raise huge problems, even when they are separated from what you might consider your most sensitive data. So what they were going to be looking at was for certain habits. So they were going to be looking, for example, Facebook users who write in short, concise sentences, use lists, and arrange to meet friends at a set time and place rather than just tonight, would be identified as conscientious. In contrast, those who frequently use exclamation marks and phrases such as always or never rather than maybe could be categorized as overconfident. Now, arguably, what Admiral were looking for was a sign of what's going on inside your head. Presumably, the kind of data that could be going into this algorithmic risk assessment could also be things like whether or not you're on Facebook at 2 o'clock in the morning because you can't sleep, or indications that you might be worried about things, or indications that there might be flags about anxiety or mental health problems. The selling point was the potential to reduce insurance premiums, but obviously you may well find that your insurance premiums are absolutely not reduced and that therefore you are paying at a higher level because the algorithm has identified you as a risky kind of a person. These kind of risk assessments that go beyond identifiable points. So clearly, if there's a photograph of you with a bottle of vodka and your car keys in hand at a great party, that might give an indication to a car insurer that you should be categorized as a high risk consumer. These kind of assessments are really going on something much more granular and deeper that you have absolutely no control over. It's not what you do, it's about who you are. And in my view, these kind of algorithmic risk assessments raise questions about the right to freedom of thought. And the right to freedom of thought covers what goes on inside our heads. It's the absolute nature of our inner state, if you like. It can be our emotions, it can be our ideas, it can be whether we're worrying about things. It could be just generally our mental state. And the right to freedom of thought gives us the absolute right to keep our thoughts private. So for inferences not to be made about what we're thinking inside our head if we are not deliberately sharing them. And it also gives us the right not to be penalized for our thoughts as they go on inside our heads. As I say, it's very different what you do, but what you're thinking is something that you are entitled to think privately and completely inside your head. So the kind of human rights and equality questions that are raised by algorithmic risk assessments, as I say, go beyond the rather dry questions of data protection. They're absolutely about our humanity. And so what I would say in terms of fintech and algorithmic risk assessments is that as a financial services provider, you need to be very careful and understand that treating your customers fairly means knowing that when the computer says no, it is absolutely not violating your customers' human rights. And if you can't explain it, you can't show that you are treating your customers fairly, in fact. Thank you.